Hello students, welcome to Recitals in Depth. In this episode, we are going to cover the topics which are featured under the section of Polity and Governance for the month of November 2024. The topics are broadly falling under the broader themes of constitutional history, federalism, reservations, police reforms, important Supreme Court judgments, and governmental bodies and schemes. Hello students, welcome to Recitals in Depth for the month of November 2024. Now let us try to see the topics that we are going to cover today. So ultimately, November 2024 marks a very important milestone in India's political history. You must be thinking why? So the answer is very clear. So this November 2024, it is marking the 75th year of the adoption of our constitution. And it is a very significant event with respect to our political history. And that is why we have two important topics from that area as well. And apart from it, there are further very important topics with respect to the Aadhaar, with respect to the panel examining whether the SC status should be given to the Dalit converts who have converted to Christianity or Islam. Also, we have Debroy committee report as well, and also very important significant judgment which has been provided by the Supreme Court of our country, that is the bulldozer justice judgment. So now let us try to come to the first topic, which is a lesson from Constituent Assembly. Now, as we already noted that the context of this particular topic is very clear, that on 26th November 1949, our Constituent Assembly had adopted the constitution of our country, and on this 26th November 2024, it completed 75 years of its adoption. And such kind of milestones are very important from the examinations point of view. That UPSC, they have an inclination to ask questions from a particular event if it has completed any kind of events or a temporal event, whether it might be a 50-year anniversary or a 75th anniversary. So specifically for the adoption of Constitution, we completed 75 years, and that is why it makes this topic a lot important. Now, in this context, what we need to understand is the role of the Constituent Assembly. Now, as we know that the Constituent Assembly was formed under the guidelines of Cabinet Mission, and ultimately, it was the role of the Constituent Assembly that it led to the formulation of our great Constitution. So, ultimately, the Constituent Assembly was performing two separate and complementary functions. One was to create the constitution by being a Constituent Assembly, and another, at the same time, it was acting as our provisional parliament as well. And can you imagine the situation that in the time of 1946 and 1947, when the Constituent Assembly started working on various provisions of the constitution, trying to design and draft the various provisions of the constitution, the country was going through a very tumultuous period. On one hand, there was partitions, the wounds of partition, communities were battered, and a lot of decolonization was taking place not only in India but also in the South Asia. So the entire political ecosystem of the South Asia was quite disturbed, and to create such a monumental piece of law, that is the constitution, at such sensitive time is again a marvel which was achieved by the Constituent Assembly. But do you think why the Constituent Assembly was able to create such a monumental piece of law? Because ultimately the Constituent Assembly were exercising certain very important principles. And what were those principles? The principle of dialogue. They were always in the favor of initiating a dialogue to go for 3 Ds. What are these 3 Ds? Discussion, deliberation, and debate. And these were the principles which were actually followed by the Constituent Assembly, and that is why they were able to forge consensus among various parties and members, among various diverse set of members who were coming from various different ideologies, different sects, religions, caste, races, etc. And it was only their spirit to hold dialogue, to discuss, deliberate and debate on various issues, and secondly to forge consensus on various issues pertaining to our Indian society, which led to the formulation of our constitution. Now, what we need to understand is that ultimately we have to draw lessons from how the Constituent Assembly was functioning for today's parliament. And for that, we need to contrast the functioning of the Constituent Assembly with the functioning of today's parliament, and what kind of parliamentary culture is actually evident in present times. So, unfortunately, the values and the principles which were exercised by the Constituent Assembly has eroded a lot in the last 75 years of our existence. So, the values and principles which are quite dominant in today's parliamentary functioning are very simple. That is, it is dominated by partisan politics. It is dominated by disruptions. It is dominated by majoritarianism. And also, lastly, it is dominated by lack of consensus. And we are going to discuss all these things with the help of certain graphs that I have put over here, so as to make you understand how our parliamentary democracy is functioning, how our parliament, which is the largest forum of our people's representative to discuss and deliberate on the issues which are facing the society, and how ultimately they are performing. And since these are the core symptoms or the principles which are being exercised by the today's parliamentary culture, it is quite contrasting to the principles which were exercised by the Constituent Assembly. And those principles were to go for dialogue, and on the other hand to build more and more consensus. So now let us try to see the performance or the functioning of the parliament in post-independence era. So how do we actually identify the performance? So we need to find certain metrics so as to measure the effectiveness of the parliament. So the first thing can be the number of sittings the parliament is making in a particular session. So this first graph is related to that only. Now from the graph itself, you can see that graph has plotted that annual number of sittings a particular Lok Sabha has made over the years. And if you'll see, the first Lok Sabha in the first year or annually, they sat for an average of 135 sittings, which ultimately reduced to only 55 number of sittings in the 17th Lok Sabha, which ended in 2024. So it started from 2019 to 2024. And you can see that if we'll trace the graph, it is very evident that over the years from the first Lok Sabha to the 17th Lok Sabha, there has been a very consistent gradual decline on the number of annual sittings a parliament is making. So do you think that parliamentarians are getting enough time to deliberate on the issues which are facing our people? The second important point is the degree of legislative scrutiny. Now, Parliament, although even if they are going for 135 sittings annually in an year, they will have less time to discuss and deliberate all the bills at length. So, that is why the Parliament of our country has come up with parliamentary committees, which provides for more detailed scrutiny and examinations of various provisions of the bill. And secondly, it provides for expertise and expert comments on those particular provisions of the bill. And if you'll see this particular graph, that earlier in the 15th Lok Sabha, 71% of the bills were being referred to the parliamentary committees for detailed examination and scrutiny. However, you will be surprised to know that in the 17th Lok Sabha, that is, which started from 2019 to 2024, only 16% of the bills were referred to the parliamentary committees, which actually highlights the decreasing level of scrutiny which has to be done by the parliament with respect to the legislative proposals. And again, this is a very alarming situation, just like we saw in the previous graph as well. Now let us try to see the other markers of efficiency as well. Now this particular graph, this third, it shows the time spent for passing of a bill. Now the time spent is directly proportional to the quality of the discussion over that particular bill? Now, from the graph, it is quite evident that this blue portion, which is evident over here, it shows that this bill has been passed in less than 1 hour. And can you imagine that 35% of the bills were passed in the parliament not exceeding a discussion of an hour? Can you imagine this particular situation? And if there is no scrutiny, debate and discussion over a bill, can you imagine what kind of accountability the parliament is actually enforcing on the legislative proposals which has been made by the parliament? So these are very alarming trends. The fourth is the amount of time spent on the budget. Now again, if you'll see, from the first Lok Sabha to the 17th Lok Sabha, again we are able to see that the average time spent on the union budget discussion is on a gradual decline itself, and it started from 138 to 143 hours in the second and third Lok Sabha, and it has come down to even 13 hours discussion, 35 hours discussion. That is the level of decline in the quality of time spent while discussing the debate, while discussing the budget. And that is why these graphs are showing the gradual decline of the authority of the parliament, that the effectiveness of the parliament is directly being impacted by the metrics that we have just shown. One more metric that we should try to keep in mind is the quality of MPs, that the quality of member of parliaments. Again, for every Lok Sabha session, we are seeing the level of criminalization, level of criminals in every Lok Sabha. It is increasing every year by year. Apart from it, the sixth metric that we need to understand is the millionaire MPs. So again, the number of millionaires is again increasing for every Lok Sabha election that we are conducting. And this shows that the parliament, the way it was conceived to function, it is absolutely not functioning in those terms. And that is why when we say that the constitution has completed its 45 years, 75 years of its completion, it gives us an opportunity to reflect on the functioning of the Constituent Assembly, to reflect on the ideals which were enshrined in the Constituent Assembly, and to actually take some lessons or draw some lessons from it. So what are those lessons which can be taken from the Constituent Assembly for today's functioning of the Parliament? So we can understand it with the help of threefold lessons. So the first lesson will be adherence to more and more dialogue. Second is to go for consensus building. And third is bridging ideological divides. Now let us try to understand these three elements or these three lessons one by one. So firstly, the parliament should focus on constructive dialogue, and respectful disagreement. I would like to quote certain instances from the debates of the Constituent Assembly itself. So there were certain members like KT Shah, etc., which who were dissenting a lot with respect to the provisions which were put forward by the our honorable member, which is Dr. B.R. Ambedkar. And Dr. B.R. Ambedkar, although if you have to compare it with present times, any MP or any member of parliament might take offense if any particular person is trying to show a dissent. However, the Constituent Assembly, they try to encourage healthy dissenting, and that is why they try to encourage respectful disagreements as well, because ultimately the dissenting opinions, they try to enrich the ultimate outcome of the discussion. And that is why B.R. Ambedkar at various instances, he applauded KT Shah as well for showing his respectful disagreement with the opinions which were put forward by B.R. Ambedkar. The second important point is that we need to note over here is this consensus building. Now, Indian society and India as a country is facing a lot of problems, whether be it respect to the poverty, inequality, unemployment, climate change, lack of growth, or tapered growth. So a lot of problems is being faced by our country, and ultimately to provide a very common solution or a very viable solution, we need to be our solutions has to be driven through more consensus driven solutions rather than majoritarian imposed decisions. What do I mean by that is that ultimately democracy is run by majority. However, the decision should not be driven through majority in ethical domain. It should be driven through more consensus, that ultimately the ruling party should try to bring in the opposition party as well while trying to devise better solutions for the issues which are being faced by our society. The third important is bridging ideological divides. And what do we mean by that is that ultimately the parliament again is a forum of great diversity of people who are coming from different ideologies, and we need to understand that the 21st century problems are extremely complex, and adhering to one single ideology will never yield a very viable result. And that is why we need to bridge our ideological divides to devise such kind of governance model which is inclusive and supports rapid economic growth as well. Rapid economic growth. So these are the important lessons that our parliamentarians have to derive from the functioning of the Constituent Assembly, and ultimately if we are able to integrate such principles in the functioning of today's parliament, our parliament will emerge as a very efficient and effective organization for the democratic politics. Now let us try to come to the next topic, which is poll nomination proposers. So again, it's a very important topic, and I would like to teach you with the help of a very story. So the context is nothing but the story. So ultimately this topic, as the title suggests, that it is related to the poll nomination proposers. So in the beginning of the lecture itself, I am just trying to set the note, that is, if a particular candidate wants to contest an election, so they have to file a nomination paper in front of EC or the returning officer, and this nomination paper of a particular candidate has to be endorsed by a proposer. And if the returning officer, it finds the nomination paper to be in the right format and all the details of the proposer and the candidate to be accurate, then this nomination paper is accepted, and then only this particular candidate will be able to contest the elections. This is the core concept associated with this particular topic. Now let us come to the story. Now what happened, that there were elections in the state of Jharkhand, especially on the date of 13th of November and 20th of November. And what happened, that the ruling CM who belonged to the Jharkhand Mukti Morcha as a party, that is Hemant Soren. Now he also wanted to contest elections since he was a CM, and since the elections were due in the state of Jharkhand, he wanted to file the nomination. And to help him file the nomination, he wanted one proposer. So there was one proposer by the name of Mandal Murmu. Now what happened is that there were certain apprehensions by the party workers of Jharkhand Mukti Morcha, that ultimately they felt that this Mandal Murmu, while providing the information in the nomination papers for the incumbent CM of Hemant Soren, he has provided wrong information, since Mandal Murmu was accused of he might shift away to the party of BJP. So he can be, so ultimately the JMM or the Jharkhand Mukti Morcha members apprehended him of that he will go for some malified activities by providing wrong information in the nomination papers which were filed by the Hemant Soren. And ultimately what happened is that while Mandal Murmu was going to meet certain BJP MPs, police detained him and ultimately put him for detention for a good period of time. And it ultimately created a lot of political stir in the political climate of the Jharkhand since the polls were due. And this particular issue was also raised by the Chief Election Commissioner of our country as well, that why did the police try to nab or detain Mandal Murmu while the Model Code of Conduct was in operation. And that is why, that is the core of the core story behind this particular thing. Now, as we know that ultimately Mandal Murmu claimed that he went to meet the BJP MPs to discuss various issues which are confronting the Jharkhand. That was his idea. But what we need to understand from the examination point of view is that what are the role of proposers, what are the legal nuances associated with it, and whether if a proposer provides wrong information willfully, can it lead to the cancellation of nomination of a valid candidate. So now let us try to understand these concepts. So who are the proposers? So as we already noted that proposers are people who are listed in the electoral roll either of a constituency for general elections or for local legislative elections. And the function of the proposers is to endorse the candidature of a candidate who is filing the nomination paper in front of the returning officer. Nomination paper in front of the returning officer, which is appointed by the Election Commission of our country. Now, second thing which we need to note over here is that the proposers of a particular candidate need not belong to the same political party or not at all belonging to a political party at all. Okay. And thirdly, if we need to have a proposer, so a candidate will be needing one proposer only if that particular candidate belongs to a recognized political party, and the same candidate, if they are belonging from an unrecognized political party, they will be needing 10 proposers. Now, the question will come to our mind that what is recognized and what is unrecognized political parties. So for any group to contest elections, they first need to get registered with the Election Commission of our country. And then based on certain criteria which we will discuss right now, the Election Commission of India labels them as either recognized or unrecognized. The recognized political parties are of two types, that is the state and the national parties. So if any candidate who is willing to contest the elections and this candidate is belonging to the recognized political party, they just need only one proposer. And if any person who wants to conduct the election and they are belonging from unrecognized party, they need 10 proposers. So what is the core definition of say a national party? So ultimately any party will be labeled as national party if it secures 6% of valid votes in 4 or more states at a general election to the Lok Sabha, or, that is the key term over here, or to the legislative assembly and wins 4 Lok Sabha seats. The second condition is if it wins 2% of the Lok Sabha seats with members from at least 3 states. And the third is if any party is recognized as a state party in 4 states. So those parties will be considered as a national party. Now let us try to look and appreciate the conditions which is to be adhered to be recognized as a state political party. So any party will be provided a recognition of state party if it secures 6% of valid votes in state legislative assembly election and wins 2 assembly seats, or 6% of valid votes in Lok Sabha election from the state and wins 1 Lok Sabha seat, and thirdly 8% of total valid votes in Lok Sabha or state assembly elections. So this was added only in the year of 2011. And thirdly, if it wins 3% of seats or a minimum of 3 seats in assembly, whichever is more, and 1 Lok Sabha seat for every 25 Lok Sabha seats allotted to that particular state. So if any political parties are falling under these criteria or are able to qualify these criteria, they will be labeled as national party or the state parties. Now, the same RPA Act, the Representation of People Act of 1951, which provides for the various provisions with respect to the proposers, it provides that for the election of president and vice president, they will be needing 50 proposers as the first proposers and plus 50 as secondary proposers. So ultimately, for the elections, for any person who wants to contest elections for president or vice president, they will be needing 100 such proposers in a way. So 50 first proposers and 50 secondary proposers. Why? Why such high threshold? So as to discourage any kind of malified and spurious candidature with respect to the contest elections to the office of president and vice president, so as to save the resources of Election Commission of India, whether it be time, money and the financial resources. Now, what are the role of proposers in nomination filing? Now, as we know that ultimately it is a proposer who needs to endorse the nomination of a particular candidate. So ultimately the proposer has to provide their name, electoral roll, number and signature in the nomination papers of a particular candidate. And secondly, whenever the candidate is trying to submit the nomination papers in front of the RO, that is the returning officer, either the candidate or the proposer has to be present. They have to be present. So these are the roles which are played by the proposers in the process of nomination filing. Now let us try to see what can go wrong with respect to, say, the proposer. Can a nomination be rejected on the account of the proposer? So the answer is absolutely yes. So it can be rejected if they are not submitting the nomination papers on time. Secondly, the nomination papers are submitted by some other persons apart from the candidate and the proposer. And thirdly, if the RO finds or the returning officer finds that ultimately there is a malified role of proposer, that is, if the returning officer finds that the name or the identity details of the proposer does not match which has been provided in the nomination paper, and ultimately if such kind of conditions fall true, then it might lead to the cancellation of candidature of a particular candidate. And that is why the Jharkhand Mukti Morcha members were apprehensive of the whereabouts of Mandal Murmu, because they felt that ultimately Mandal Murmu might defect or might switch to the BJP by providing malified information or willfully wrongful information for filing the nomination paper of Hemant Soren. And is there any precedent to it? So ultimately a very important event happened in 18th Lok Sabha elections. 18th Lok Sabha election. So ultimately 18th Lok Sabha we constituted in the year of 2024, May. So what happened in the constituency of Surat, BJP candidate Mukesh Dalal, he won the elections without contesting. Now you might think that how is it possible? How can a particular candidate of BJP can win the election without even contesting? So what happened is that in the Surat, there was a Congress candidate by the name of Nilesh Kumbhani. And Nilesh Kumbhani had filed 3 nomination papers with 3 different proposers. And what happened is that in front of the returning officer, all the 3 proposers of Nilesh Kumbhani, they backed out. They told the returning officer that whatever sign which is present in the nomination paper of Nilesh Kumbhani were not there. So ultimately, the three proposers which were picked by Nilesh Kumbhani, they deceived Nilesh Kumbhani, and which ultimately led to the cancellation of the candidature of Nilesh Kumbhani. And since he was the Congress candidate and was the main proponent of the BJP, so what happened is that all the independent and smaller political parties, they withdrew their nomination files, and ultimately there was only one candidate from the Surat constituency, which was Mukesh Dalal, and which led to winning of Mukesh Dalal of the seat of Surat constituency without even contesting the elections. So these things actually go about in our Indian political life, and it shows very badly on the ethical premises which the proposers portrayed in the case of Nilesh Kumbhani. So it was a very interesting topic, and I hope that this portion is very clear, and you might expect a question in the prelim examination from this part. Let's come to the next topic, which is Aadhaar cannot be used as a proof of date of birth. So what is the context? So recently Supreme Court in a judgment, it held that Aadhaar, it cannot be used as a proof of birth, proof of date of birth, since it can only be used as a proof of identity. And the Supreme Court also held that ultimately to ascertain the proof of date of birth, all the governmental agencies or any private agencies should go for matriculation certificates, or the school leaving certificates. Now this was why we are trying to learn this particular topic is that because Supreme Court provided this judgment very recently in the month of November 2024. Now what was the story ultimately? Now the story goes like the Supreme Court was reviewing a petition which was dealing with the compensation to a family with respect to a person named X who got deceased in a road accident. See, we need to understand the story in the politics as well, or the functioning of the various judgments as well, so that ultimately we will be able to understand the core essence. We will be able to remember such information and facts for longer period of time. Okay, so there was a person X who got deceased in a road accident, and now ultimately what happened is that Motor Accidents Claims Tribunal, it directed the insurance companies to pay the family of the deceased person a sum of rupees 19 lakhs. Now the insurance companies, they went to the High Court of Punjab and Haryana, where the Punjab High Court decreased this particular compensation amount to rupees 9 lakh. And why did the High Court decrease the amount of compensation? For that we need to understand one very important concept. Now according to the Motor Vehicle Act of 1988, whenever there is such kind of fatality with respect to the road accidents, the amount of compensation which will be received by the family members is a function of important variables. That is, the age of the deceased person, the income of the deceased person, whatever income that the person who got deceased was making, and the number of dependents. Now in determining an absolute and a just amount of compensation, any insurance company has to look into these three elements. What do we mean by age over here? Now the compensation is directly proportional to the age. That is, the compensation will be more if the age of the deceased person is less, because if the deceased person would have lived, he would have generated more income and revenue for the family, and that is why if a person who is dying younger, he is eligible to get more and more compensation from the insurance firms. However, when the Punjab High Court, it reduced the compensation which was provided by the Motor Accidents Claims Tribunal to 9 lakh, it took the age of that particular person to be 47 years. And Punjab High Court said that ultimately it is given in the Aadhaar of that particular person X. And ultimately what had happened is that the family was claiming that ultimately the person X was having the age of 45 years, which was based on the matriculation certificate. And because of these things, this particular case landed in the Supreme Court of our country, and Supreme Court had to intervene in the functioning of Punjab High Court, and ultimately Supreme Court provided for certain observations which we will discuss over here. So what did the Supreme Court observe? That ultimately it reprimanded the Punjab High Court, that is, it directed the Punjab High Court that why did it intervene in any matter of Motor Accidents Claim Tribunal, because ultimately a High Court should entertain such kind of pleas only when there is any kind of mala-fide motive or illegality which has been done while determining the compensation amount for the deceased person X. The second it noted is that for a proof of age, the Supreme Court highlighted that the section 94 of the Juvenile Justice Act of 2015, it is already evident that Aadhaar can't be used as a proof of birth. And what is the proper evidence for the proof of birth? It should be your school leaving certificate or the matriculation certificates. And the third important point which the Supreme Court highlighted is that the compensation. So the Supreme Court again increased the compensation, which was reduced to 9 lakh by the Punjab High Court to rupees 15 lakh. And the Supreme Court considered the school leaving certificate or the matriculation certificate of that deceased person X as a proof of birth. So in that case, it became a very important and a prominent judgment, so that the compensation which was due for the family of X, ultimately it got increased. However, we need to understand the larger debate that about the Aadhaar. So what is Aadhaar? So Aadhaar is a 12-digit unique identification number which is issued by the Unique Identification Authority of India, that is the UIDAI, on behalf of the Government of India, and it is serving as a proof of identity and address, and it does not serve as a proof of birth and citizenship. So these things we need to keep in mind, because it can be formed in a very smart statements in the prelim examination, that Aadhaar does not serve as a proof to their birth and say citizenship. Now what is the eligibility condition for it? So any resident of India. So this means that this particular Aadhaar document is not only relegated to the citizens of our country. Any person who is staying in India, regardless of age and gender, can enroll for Aadhaar if they meet UIDAI's verification requirements. Now what is the procedure for enrollment? Individuals need to enroll only once. Multiple enrollments are flagged and are considered as duplicates. Enrollment is free of charge for all the residents. Now let us try to see the value of uniqueness over here. Now since each Aadhaar number is unique to the individual, it might provide for better safety of that particular individual's identity, since there cannot be any kind of fake identity cards for a particular individual. About the validity, it will be valid for the lifetime of that individual, and benefits we are going to discuss in quite depth and detail in the next section. But before that, we need to understand how the scope of Aadhaar has evolved over the years. Now the Aadhaar, initially it was conceived as an idea to be provided to the BPL family members, that is below poverty line families, so as to identify them accurately, And since these BPL families were recipient of a lot of subsidy programs from the government of India, government wanted to identify them with a very unique identity number, and that is why the idea of Aadhaar had initiated. The idea of Aadhaar was conceived. However, with time, the Aadhaar was issued to the entire residents of our country. Now, the Aadhaar bill was passed as a money bill in the year of 2016, and it was hotly politically contested debate with respect to whether Aadhaar bill could have been used as a money bill or could have been passed through the instrument of money bill. And in the year of 2018, in the Puttaswamy judgment, the famous Puttaswamy judgment, the Supreme Court provided for very important guidelines with respect to the use of Aadhaar. So what Supreme Court held that ultimately Aadhaar cannot be forced to be used for, say, educational enrollments, or to get a mobile SIM card. However, if any particular person is trying to receive any kind of subsidy or governmental benefits, then in that case the person has to have Aadhaar. And secondly, for linking of PAN, that is the permanent account number, with the Aadhaar is mandatory. So these were the two important highlights which were provided by the Supreme Court in the Puttaswamy judgment of 2018. Now let us try to see the implications of using Aadhaar, in the sense of what are the positive implications and what are the negative implications of using Aadhaar. So the first is very clear, that is the streamlined welfare distribution. So ultimately, as we know that the government is having, the union government is having a lot of subsidy budget, and to provide for a very streamlined welfare distribution that the subsidy reaches the desired targeted beneficiaries, it is well in the favor of the government to have such unique identities of those people in a centralized database, so that the subsidy is getting debited from the government's account and it is getting credited to the receiver's account, and that is only possible with the help of a unique identifier, which is Aadhaar over here. Secondly, reduced identity fraud. Now, as we know that the Aadhaar is a unique number for every individual, and since it is so unique in nature and it is generated in a centralized manner, it will lead to reduction in the number of fake and duplicate identity cards which are issued. So it might lead to reduction in identity fraud as well. The third important thing that we can, or the benefit we can see, is that the level of financial inclusion. Now, with the help of Pradhan Mantri Jan Dhan Yojana, along with the linking of PAN with the Aadhaar, what it has done is that all the financial intermediaries, whether be it banks, non-banking financial institutions, they are using the Aadhaar database to go for the Know Your Customer norms or the KYC norms, and that is why they are able to perpetuate the credit penetration in the society of our country, and the credit or the banking services are reaching to the hinterlands of our country. The fourth is efficiency in governance. Now, as we know that government is providing subsidy to various large number of people through various ministries, and ultimately a particular beneficiary is getting subsidy from various departments of our government, and ultimately whenever there is more and more collaboration among the different governments or among the different levels of government and within the government, different departments of the government, it will lead to more efficiency in governance with the help of Aadhaar, since government will be able to track the absolute flow of money from different channels to the bank account of different beneficiaries. The last is ultimately it is going to promote Digital India by providing a foundational identity system which will facilitate digital services and enabling interoperability of services not only within the government but also with respect to the government and the private sectors. Now, let us try to understand and appreciate what are the concerns associated with the implications of Aadhaar. So, the first is the privacy concern. Now, since Aadhaar is providing unique identity to every individual, and to provide that identity, UIDAI is also taking a lot of biometric information and personal information of that individual, and they are trying to store it in their own servers, which might lead to a lot of privacy concerns in lack of strong data protection regimes. The second is the data security risk. Now, whenever the UIDAI is trying to store the data of millions of our citizens and residents of our country, it might get exposed to different kind of cyber threats or cyber risk, and it might lead to the leaking of data, which has happened all across the world with respect to if any company is storing the data. And it is not uncommon a feature that ultimately there is a large data breach by notorious activities of certain antisocial elements. The third is the exclusion from welfare services, which means that now, for example, let's try to understand it with the help of an example. For example, a student will be able to avail the midday meal scheme only if he or she is having the Aadhaar. So first level of exclusion happens if the student is not having the Aadhaar. The second is, even despite having the Aadhaar, there might be a technical problem with respect to the functioning of the Aadhaar, that the fingerprint is not matching, etc. So such kind of things, or there is lack of internet connectivity. So it might lead to exclusion of the welfare services as well. The fourth is the potential for surveillance. Now, as government is having all the data of the individuals, and the Aadhaar card is linked to and feeded to other activities of the individual as well. So in that case, it leads or it provides an opportunity for the government to provide for a surveillance of the citizens as well, which is again going to impinge on the privacy of our individuals. And lastly, dependency on a single system. Now, since we know that the UIDAI is an extremely centralized system, and if we are depending on a very centralized and a single system, and if it collapses, unfortunately, it will lead to very disastrous consequences, not only for our country, but for also our citizens and for the effective functioning of our governance as well. So Aadhaar, so as to say, is a very monumental technological intervention which has been developed and evolved by the government of our country to provide effective service delivery, and so as to monitor various programs of the government as well. But what we need to realize is that we need to create a very strong data protection regime as well, so that whatever data the UIDAI is trying to extract from the individuals, they are safe, and these data are not used against the benefits or the interest of those citizens. So this was all about this topic. Let's come to the next topic, which is again very, very interesting, which is panel for scheduled caste tag for Dalit converts. Now, this is one of the most important topics that we are going to cover in this particular episode, so be very attentive. Now, what is the context? So, recently the government, it provided extension to a committee. And what is that committee? It is a commission of inquiry to look into whether the scheduled caste status should be given to Dalit converts if they are converting to Islam and Christianity. And this particular commission of inquiry is headed by our previous ex-Chief Justice of India, that is K.G. Balakrishnan. And this committee was formed in the year of October 2022, and with the extension, it has been provided a 1-year extension till October 2025. Now, the core idea on which this particular commission of inquiry has to ponder is that whether the government should extend the scheduled caste status to all those Dalits or the depressed classes who are converting to Islam and Christian. Now, at the onset of this lecture itself, let me put forward a very basic status of scheduled caste reservation. Okay. So, all the Dalits or the depressed classes which are identified by the government of India, are provided the status of scheduled caste. What is the scheduled caste? We will try to discuss it in quite detail, what are the constitutional provisions, but I am just trying to set the note over here so that you will get a very good understanding of it. However, imagine a situation where this particular scheduled caste person who is belonging to a particular scheduled caste, he or she changes their religion. Now, for instance, if a person who is belonging to a scheduled caste in Hindu religion, if they change to Buddhism or Sikhism, then in our current constitutional paradigm, these people will retain their status of being labeled as scheduled caste. So these people will get all the benefits associated being scheduled caste, that is reservation to educational institutions, public employment. However, if the same person converts to other religions, that is Christianity or Islam, now the same person will not carry forward the title or the status of scheduled caste. So these persons will be deprived of all the benefits which they might have accrued by having the status of scheduled caste. So that is the current status which is being followed and practiced in our country. Now this commission, which is headed by K.G. Balakrishnan, had to look into this particular issue itself, that whether should we extend the reservations of scheduled caste for Dalit converts or the Dalit persons who are getting converted into Christianity or Islam, so that we can also provide scheduled caste status to the converts who have converted to Christianity or Islam. So the K.G. Balakrishnan committee is looking into this facet itself. Now we will try to understand what is scheduled caste, what are the criterions and the procedure for a particular community to be labeled as scheduled caste, and what are the core arguments which are there for which the government has provided for such kind of scheme where government is not providing scheduled caste status to Christianity and Islam. So now let us try to understand the first important thing is that what is scheduled caste. But before we go on to the scheduled caste, let us try to see why the extension was provided to this particular K.G. Balakrishnan committee. So ultimately there were initial operational delays that the commission noted that the commission could not even start functioning till August 2023 after creation in August 2022 because they were not given office space. So this itself shows and highlights the level of importance which the government is giving to this particular committee. The second is delayed field visits. So again the commission could not start with field visits to interview and do surveys because ultimately they were short of staff. And thirdly, public consultations. Now since this particular commission has got a very significant task of actually identifying the condition of Dalit converts. That is, whenever a Dalit person is getting converted from Hinduism to say Muslim or Hinduism to Sikhism, whether there is any change in the socio-economic parameter of that particular individual or of that community. So ultimately it requires a lot of public consultations with respect to the people, communities, various research organizations, and for the commission to perform such public consultations, it requires more time. And that is why the commission also requested that they need more time, and that is why the government also provided them a year-long extension which will end in October 2025. So in all totality, we are going to discuss the recommendations which will be provided by this commission in next year. So now let us try to come to the core conceptual element of this particular debate. That is, what do we mean by scheduled caste? How does the constitution define it and delineate it? What are the criterions that we are trying to follow? What is the procedure with respect to the inclusion or exclusion of a particular community with respect to the scheduled caste? And ultimately then we will try to see that what are the core arguments with respect to the central government, that why they are not extending the scheduled caste status to the Dalit converts who are getting converted to either Islam or Christianity. So now let us start with the first element, which is what do we mean by scheduled caste. Now the constitution under article 341 of our constitution, it provides for the provision for the scheduled caste. Similarly, article 341, since it provides for scheduled caste, 342 it provides for scheduled tribe, and 342A it provides for socially and educationally backward classes. So for this particular topic, our interest is over here in the provisions of Article 341. And what does the Article 341 says? So Article 341 says that in the clause 1 it says that the president may, with respect to any state or any UT, after consultation with the governor of that particular state, may notify by public notification. It can specify any caste, race or tribe. Note these three terms. Or parts of group or the caste groups within the caste which shall be deemed to be called as scheduled caste. So these groups will be deemed to be known or called as scheduled caste for the purpose of this constitution. By utilizing this power which was provided by the Article 341 clause 1, the president of our country, since the commencement of our constitution, he notified by this public notification, he issued Constitution Scheduled Caste Order 1950, which contained all the names of the communities which were to be named as scheduled caste, so that these communities will be able to receive the benefits of reservation, whether be in educational institutions, whether be it public employment, whether be in the constituency levels for contesting of elections. The second important clause that we need to note over here is the 341 clause 2. And what does this particular clause says is that the parliament by law either include or exclude from the list. What is that list? What is this list? This is the particular list. This list we are talking about. So the president, it has published a particular list by utilizing the power which has been given by Article 341 clause 1. So it has published Constitutional Scheduled Caste Order 1950, and then the Article 341 by clause 2, it provides the power to the parliament to either include more names into this particular list or to exclude names out of this list of any community that they feel to be labeled as scheduled caste. So this is the core of the core definition, constitutional definition or labeling which has been dealt in Article 341. However, what is the criterion that is being used? So the criterion to identify the scheduled caste, that a community will be labeled as a scheduled caste for the purpose of this constitution, is the social, educational and economic backwardness which is arising out of traditional practice of untouchability. And that is the core of the core criterion which the government of India is using to label any community as a scheduled caste. That is, if the government of India feels that through various like research by various commissions, etc., if they feel that a particular community is lacking in social, educational and economic fronts because they were subjected to the traditional practice of untouchability, then the government of India will label that community as scheduled caste under the, as provided under the Article 341 of our constitution. However, what is the process which is used by the parliament of our country or the government of our country to include or exclude any community in the scheduled list or the constitution scheduled caste order of 1950? So what it does is that the process of inclusion, it starts with the state government. Now what happens is that the state government of our country, of it can be any state, it proposes to the central government that certain communities, say X, Y, Z, should be included in the presidential order of scheduled caste. Now in the second level, the state government sends this proposal to the central government. In the third stage, the central government asked the Registrar General of India and the National Commission for Scheduled Caste to examine and scrutinize the proposal which has been put forward by the state government. So Registrar General of India and the National Commission of Scheduled Caste, it will examine it and they will try to find out and investigate whether the community concerned, that is the XYZ, do they really belong to the scheduled caste or should they really belong to the category of scheduled caste, because ultimately they will try to identify whether this particular community of XYZ, whether they faced social, economic and educational backwardness because they were discriminated against and they were the victims of the practice of untouchability. And if they found the proposals to be correct, ultimately the central government, it prepares a bill to amend the Constitution Scheduled Caste Order of 1950, which was published by the President of our country under Article 341 Clause 1, and by passing it with simple majority, these communities, that is the XYZ communities, will be added in the or included in the SC list. This is the list. So this is the core procedure for the inclusion, or the same procedure works for the exclusion of as well. You must have occurred in the newspapers as well that recently the Himachal Pradesh had put forward a proposal, and Madhya Pradesh government has also put forward a proposal that certain communities should be taken out from the scheduled caste list. So there was an exclusion, and to put those communities into the ST list. And what article governs the ST list or the scheduled tribe list, which is the Article 342 we already discussed. So now let us try to see, since we have already understood what is scheduled caste, their constitutional provisions, the criterions used for the determination of scheduled caste, and the procedure for the inclusion of the scheduled caste. Now let us try to understand what is the current status of it. Now in the onset of this discussion itself, we have discussed earlier that in the Constitution Scheduled Caste Order 1950, it identifies all the communities who are labeled or tagged as a category called scheduled caste. And if this particular person who is belonging to the scheduled caste, if they decide to convert to another religion, getting out of the Hinduism, and if they convert to Sikhism or Buddhism, they will retain their status of scheduled caste. However, whenever they will try to convert to other religions of Islam or Christianity, they will not retain their status of scheduled caste. That was the core element of this particular discussion that we had noted in the onset itself. However, when the president had issued this Constitution Scheduled Caste Order of 1950, it comprised of scheduled caste communities which pertain to only Hindu communities. It was only in the year of 1956 that the Constitution Scheduled Caste Order was amended based on the recommendations of Kaka Kalelkar Committee, which provided for the inclusion of Sikh communities, certain segments of the Sikh communities to be given the status of scheduled caste. And similarly, the religion of Buddhism was added in the year of 1990 based on the recommendation of high-powered panel on minorities and SC and ST. So based on these recommendations, the religion of Sikhism and Buddhism, after the Dalit person has converted to it, has been provided the status of Supreme Court. However, time and again, various petitions have been filed in the Supreme Court as well and the courts elsewhere in our country, so that why the Islam and Christianity are not being provided the SC status if a particular person from the scheduled caste community is getting converted to Islam or Christianity. And the logic which has been provided by the government of India recently in 2019, so the government of India had quoted the imperial order Government of India in the year of 2019 quoted the Imperial Order of 1936, where it provided the reasoning for not including the Dalit converts of Islam and Christianity into the scheduled caste category. That it said that whenever the Imperial Order, it first issued the list of depressed classes, and whenever the colonial government issued the list of depressed classes, it excluded Indian Christians. And that is the core logic the government has provided in 2019. That was the latest instance when the government of India had rejected the claims for such group of people who wanted the community of Islam and Christianity, or the Dalit converts who have converted to Christianity and Islam, to be provided the scheduled caste status. However, what are the core arguments which goes against which goes for the exclusion of Dalit Christians and Muslims? The first is impact on SC population. Now, the experts are apprehensive of the fact that if we provide scheduled caste status to Dalit converts for Christian and Muslims, it will swell the SC population in our country, and ultimately it will create an artificial demographic pressure. Artificial demographic pressure on the resources of the society. That is, whatever resources which are available to the scheduled caste as a community, whether be it the public employment or the admissions to the educational institutions or the right to contest elections from certain constituencies, or various kind of schemes and policies in which scheduled caste as a community are beneficiaries. So it will provide an undue pressure on the resources of the government. The second is the international perception. Certain experts feel that by providing or extending the scheduled caste status to the Dalit converts of Christians and Islam, it might provide for an pervert international perception that India is trying to impose the caste system in their religion. That is a foreign religion, since it was not originated in India. And the practice of untouchability. Now, as we already noted, that ultimately one of the core criterion to identify whether a community will be labeled as a scheduled caste or not will depend on the social, economic and educational backwardness of a community, which is arising out of the practice of untouchability. And this practice of untouchability is practiced in the Hinduism itself, and it was not found to be practiced in Islam and Christianity. And that is why ultimately these arguments are going against providing the SC benefits to the Dalit converts for Christians and Muslims. However, there are certain important arguments which the central government is already pushing forth with respect to providing reservation benefits to the Dalit Christians and Muslims. So the first point is, as we already noted, that both the Christianity and Islam are of foreign origin. Now, since the entire basis of providing scheduled caste is based on untouchability, and since the Islam and Christianity are of foreign origin, these religions are not having the tradition of untouchability, so as to say. And that is why the central government is not in favor in providing any kind of SC status to this thing, Islam and Christianity. The second point is whether to provide any Dalit convert to whether the Dalit convert is converting to Islam or Christianity, whether to provide them with the SC status or not, it is a matter of parliament and executive, and it has not to be dealt with any form of judicial adjudication, because parliament is the concerned body which will provide for appropriate research and investigation on the conditions, socioeconomic conditions of various Dalit converts, and then they will try to identify whether they have to provide them with appropriate reservations or not. The third is the OBC classification. The center is of the opinion that by not providing the Dalit, Christians and Muslims as scheduled caste status, since ultimately many state governments have classified them under other backward classes and they are already utilizing the benefits of reservations through that channel, so there is no need to provide for reservation under the scheduled caste status. And lastly, it might lead to the misuse of scheduled caste reservation, as we already noted that it might swell up the population of scheduled caste community in our country, and it might lead to unforeseen burden on the resources which are there for scheduled caste community, and it might lead to a kind of a demographic pressure and skewed inter-community growth within the scheduled caste as a social category. So now let's come to the next topic, which is new rules for appointing police chiefs. So what is the context? So recently in the month of November, the UP government came out with new rules which was published under the Indian Police Act of 1861. Please note the coloniality of this particular act, how ancient this act is. So UP government has to come up with new rules, and the rule is named as Director General of Police of Uttar Pradesh Selection and Appointment Rules of 2024. And since we already know that these rules have been created or formulated under the Indian Police Act of 1861. Now what we need to understand is the story or the chronology, so that ultimately if we don't understand the chronology of it, we'll never be able to understand this topic in its quite depth. So what is the story or the chronology behind this particular issue? So the story is quite simple, that the Supreme Court in the month of October 2024, it provided contempt notices to 8 state governments, UP being one. UP was one of them. And why the Supreme Court was sending the contempt notices? The Supreme Court noted that the state governments are not following the directions which were provided by the Prakash Singh judgment. The Prakash Singh judgment. Prakash Singh judgment. And ultimately, what prompted the Supreme Court to put forward such contempt notices to the state governments? Because there were a lot of petitions which were being filed in the Supreme Court, which alarmed the Supreme Court that ultimately majority of the state governments or various state governments are not following the various directions and the recommendations which were put forward by the Supreme Court in the Prakash Singh judgment of 2006. And specifically what the state governments were not doing, they were not appointing the Director General of Police. Not appointing the Director General of Police. And why they were not appointing? Because ultimately the Prakash Singh judgment has provided for the procedure, for a very specific procedure for the appointment of DGP of a particular state. And what the state governments tried to circumvent it is that since the state governments did not want to follow the directives of the Supreme Court, because they were quite ethical and they tried to insulate the top leadership of the police from the political functionaries, and for the state governments, since they wanted to avoid the directions of Prakash Singh judgment, what they did is that they did not appoint any DGP, and in place of the DGP they appointed acting DGP. And for last 2 years, since May 2022, UP government has had 4 acting DGPs till now. And this alarmed the Supreme Court that ultimately why does the state government is not following the various mechanisms which has been put forward by the Supreme Court of our country in the Prakash Singh judgment, and to circumvent the whatever recommendations the Prakash Singh judgment held, they were providing for acting DGPs, and acting DGPs are not DGPs. Acting DGPs are provided just by the ad hoc nature of selection and appointment, which has to be governed by the state government itself. So now let us try to see what were the recommendations which were put forward by the Prakash Singh judgment. So as you know that this Prakash Singh was the former DGP itself, DGP of UP, and he wanted very significant and meaningful changes in how the police is governed and managed in our country, and that is why he approached the Supreme Court, and ultimately the Supreme Court provided a Prakash Singh judgment versus the Union of India in the year of 2006, which became a fundamental ruling for the police reforms in our country, and it provided for 7 very important directives so as to reform the functioning of police in our country. Now let us try to see these 7 one by one, and then we'll try to see the tenure and selection of DGP in quite detail. Okay, so the first thing with out of the 7 doctrines, the first thing which the Prakash Singh judgment had provided is the constitution of state security commissions, and which provided for the state security commissions will be providing a broad policy guidelines for policing in the state to ensure that state police is not under the unwarranted influence or pressure of the government. The second important guidelines which was provided was with respect to the tenure and selection of the DGP. So the judgment provided for the eligibility criterions, the process which it need to follow, and for the tenure of the DGP of the state. This we will going to discuss in quite depth. Let's try to go through the various other recommendations. The third was minimum tenure of Inspector General of Police and other officers. It provided for a basic minimum tenure for even SPs and Inspector General of Police for 2 years. Apart from it, it recommended separation of investigation and law and order roles of the police. That is, the entire police department has to be fragmented into 2 parts. One should look after the basic law and order management, and secondly, another part of the police which will look only for the investigation of various cases. Next will be the Police Establishment Board, which means that it will lead to the constitution of a Police Establishment Board, which will determine the various postings and promotions of officers so as to insulate any kind of political interference in various kind of postings, so that police can function fearlessly without any fear or favor. Sixth, Police Complaints Authority. So there shall be an independent police complaints body which will receive complaints against the police and against the officers of the police department, so that it will provide a very good trust in the people of our country. And lastly, National Security Commission. The central government shall set up National Security Commission at the union level, headed by Union Home Minister, to prepare a panel for being placed before the appropriate appointing authority for selection and placement of Chief of Police Organization. So these were the core 7 directives which were put forward by the Prakash Singh judgment of 2006. Now, for this particular topic, our discussion pertains to this point, that is the tenure and selection of DGP. So what procedure does the Prakash Singh judgment put forward? So ultimately it provided that the procedure was that ultimately the state government will send a list of officers based on their experience, their tenure and service record. And state government will create a list of officers. Secondly, the state government will send this list to the Union Public Service Commission. Thirdly, the Union Public Service Commission will scrutinize this list and send back a list which is comprising of 3 officers, and the state government is free to appoint one of them as DGP or the Director General of Police. Fourth, the tenure of the DGP will be 2 years fixed tenure. And one important fix that we had to note over here, that state governments, while creating a list of officers which they will be sending it to the UPSC to be considered for the post of Director General of Police, only those officers will be put in the notices or the list who have minimum 6 months of service left. 6 months of service left at the time when the vacancy has been created for the Director General of Police. So this was the core procedure which was prescribed by the Prakash Singh judgment of 2006. Now what did the UP government do is that UP government, it came out with a rule in 2024, November 2024, in response with the contempt notice which was sent to the UP government by the Supreme Court. Since the Supreme Court noted that why did the UP government is just appointing acting DGPs and not real DGPs. So ultimately, to do away with any kind of contempt attempt, so UP government in very haste, it came out with a rule. Okay, and the name of the rule was DGP UP Selection and Appointment Rules of 2024. And this rule also provided for a specific procedure. And what procedure does it provide for? Firstly, it provided for a selection committee. And the selection committee would comprise of Chief Justice of High Court, retired Chief Justice of High Court, secondly Chief Secretary, plus additional Chief Secretary, nominated member of UPSC. So the UPSC will try to nominate a member in this particular thing. There will be a nominee from Uttar Pradesh Public Service Commission as well, a Home Department official, and lastly a retired DGP as well, retired DGP of the state. So this was the selection committee which will try to vet and examine the list of officers. Now what the state government will do is that the state government will send a list of names to this particular selection committee, and the list of officers will only be comprising of those officers who have minimum 6 months of service left at the time of emergence of the vacancy. And this selection committee will then try to provide for the appointment and selection of the officers among the list of the officers which were presented by the state government to the selection committee based on their service record, field experience, and tenure. And lastly, this rule also called for a fixed tenure of 2 years for DGP. 2 years for DGP. So these were the important procedural norms which were put forward by the rules which were issued by the UP government. Now what we need to discuss over here is that are these rules going against are these rules complying with the Supreme Court direction or not? Now as we already note that the answer may be yes or no. So why yes? So ultimately the Supreme Court directions in the Prakash Singh judgment, it had provided that the DGP has to be a 2-year term, and only those officers are eligible to be appointed as DGP who has only more than 6 months left. So these terms of whatever has been prescribed by the Supreme Court are there in the UP rule. However, one important thing which we need to note over here, and where one instance where the rule which has been formulated by the UP government can come in conflict with the directions of the Supreme Court, is that the Supreme Court in the Prakash Singh judgment has noted that the directions which has been provided by the Supreme Court will continue to be in force across the country until unless the state governments, they come up with their own act, with their own acts which will determine the appointment and selection of DGP. However, what we need to note over here, one very interesting thing is that in the case of UP, the UP government did not come with their own act. They instituted the rule under the Indian Police Act of 1861 itself. And ultimately they formulated a rule for the selection and appointment of DGP. And they did not come up with an act. And an act and a rule are two different legislative instruments. Supreme Court had wanted that all the state governments should repeal the Indian Police Act of 1861 since it was a colonial act. It did not reflect the reality of the present times, and the Supreme Court wanted to come up Supreme Court wanted the state governments to come up with more modern policing acts. So what UP did is that they initiated the rule making by utilizing the power of the Indian Police Act of 1861 itself. However, there are certain other states as well, for example Punjab, for example Chhattisgarh, who have constituted their own separate police acts which were based on the Model Police Act, which was released by Bureau of Police Research and Development. And that is why this particular rule which was issued by the UP government might come in conflict with the SC directions, because in the 2018 and 2019 judgment of the Supreme Court in the same topic of police reforms, Supreme Court had very categorically mentioned that if any state government it brings up their own laws which are in violation to the Supreme Court directions of Prakash Singh judgment, the law will not be validated. And secondly, the Supreme Court also held that the Supreme Court will be in a position to examine the state laws if they find out that certain provisions are not in accordance with the Supreme Court directions which have been put forward by the Supreme Court in the Prakash Singh judgment. And these are the core legal nuances or the legal issues which are associated with the appointment of Director General of Police in the state of UP. So this was all about this particular topic. Now let's come to the next topic. So the next topic for our discussion is swastik, and swastik is an acronym for scientifically validated societal traditional knowledge. So what is this swastik? Why do we need it? And which organization is responsible for actually administering and implementing the initiative called swastik? So now let's try to learn about it. So the first point we need to understand is that why we are trying to learn this topic, that is the context. So recently the second international communication and dissemination of traditional knowledge, TK for short, I'll be using TK itself. So CDTK conference was held and it was organized by CSIR, National Institute of Science, Communication and Policy Research. So it's one body, along with the other partner was Gurugram University. Under the aegis of Swastik Initiative. Swastik Initiative. And from the acronym itself, it is quite evident that Swastik stands for Scientifically Validated Societal Traditional Knowledge. So by that name itself, we can imagine that ultimately this initiative is here to promote the realm of traditional knowledge which is present within the communities. Now, one thing which we need to note over here is that this particular conference, which is the Conference for Communication and Dissemination of Traditional Knowledge, it was organized for nothing but to mainstream or promote the cause of traditional knowledge or the importance of traditional knowledge. So this is the thing. However, from the context itself, what we need to understand, it is very clear that Swastik Initiative stands for or is largely correlated with the development of traditional knowledge. So to understand the features and objectives of Swastik Initiative and the conducting body, which is called the National Institute of Science, Communication and Policy Research, what we need to understand even further is what do we actually mean by traditional knowledge? What are its components? How is it transmitted? And what areas can we actually apply such knowledge to gain some kind of or derive any kind of benefits? So now let us start with the core concept which is underlying this topic is actually what do we mean by traditional knowledge? So traditional knowledge can be very simply defined as any knowledge, any skill, know-how, customs or traditional practices which are prevalent within a particular community, and that particular practice or skill set is trying to provide a very viable solution to the problems which are being faced by that particular community. So in that case, the traditional knowledge which is embedded in the culture of a particular community is always trying to provide some kind of solution or any kind of aid for the betterment of the community or to solve the problems which are being faced by those communities. Now, what we need to also understand is that the traditional knowledge, ultimately it is developed over the years. It is developed over centuries of a community's existence, and ultimately with the collective effort of the members of the community, these traditional knowledge is refined and then it is ingrained in various elements of the community's physical presence. That is, the community in its various folklores, in its various rituals, in its belief systems, and certain like do-it-yourself kind of techniques are stored in these traditional knowledge are stored in these formats within the community, and the community is usually trying to solve any kind of problems which is being faced by the community. Now, one thing which we need to understand over here is that this traditional knowledge actually is trying to address the human needs and ultimately whatever the nature is providing. And this traditional knowledge is somewhat can be traced over here. That is, it emerges out of the nature's interaction, continuous interaction of the nature with the community, and over thousands or hundreds of years of interaction, the community, they learn how to utilize the nature in the best way possible for their own needs, and this is what is called as traditional knowledge. And the traditional knowledge also manifests in various forms, or it can be applied in various sectors. For example, in agriculture, for example, in animal husbandry, other examples can be medicines, various food items or cuisines, and apart from it, architecture. Now, let us try to learn this a manifestation or the expression of the traditional knowledge in these areas with the help of very beautiful examples that I have put in. Let's try to see. So, the first example that you are seeing is hailing from the realm of implementation or the application of traditional knowledge in the field of animal husbandry, that is development of new breeds. And the breed of the cow that you are witnessing over here is known as Punganur cow. Punganur cow, and this particular breed of the cow is deriving its name from the place of its origin, that is the Punganur village, which lies in the Chittor district of Andhra Pradesh. And it is believed that the Rajas of Punganur, they tried to develop this particular breed, and from the imagery itself you can see that these breeds of cows are extremely small in size, as you can see from the image itself. And for instance, I have taken these photographs because recently in this year itself, on the eve of Makar Sankranti, that is on 14th of January 2024, Narendra Modi, our Honorable Prime Minister, he tried to feed and caress these breeds of cows as a sample thing, and through this thing, this particular cow breed gained a lot of popularity among the social media, and that is why it raised curiosity among various sections of the society with respect to the utilities of such kind of cow breeds. So what utility does this particular cow breed holds? Is it only related to the aesthetic, that this cow is very smaller in size and it's quite petable and it looks very cute? So it is more than what it offers. It is offering more than its own beauty. So ultimately this Punganur cow is known for its adaptation to droughts. Secondly, it can survive with minimal food like dry grass, straw, hay, etc. And thirdly, the most important point, usually the fat content in milk of the cattle across our country, it is usually hovering in the range of 3 to 5%. However, you will be surprised to know that the fat percentage in the milk which is provided by this particular cow, it is hovering in the range of 8 to 10%, which is almost double the average percentage of fat which is found in the cow, in the milk which is provided by the normal cattle of our country. So these are the things which are very important with respect to this particular cow breed, and this cow breed has been developed with the traditional knowledge, and the community which led to the development of this particular breed, they knew their local requirements, their local challenges, that their area was drought prone, that it was parched, and ultimately we should try to develop such kind of breed which should be easily manageable, which should take less space, which should give more qualitative milk, and which can survive in minimized food. And such kind of traditional knowledge is trying to solve the human problems. So let us try to see the other examples. Now, one very important, very interesting example is the important cuisine from kola khar, or it's an agricultural commodity. It is derived from two terms, which is kola and khar. Khar means salty and kola means banana. Banana in Assamese. So ultimately this kola khar is derived from the remnants of banana plant as well. So what we see over here is that parts of banana plant are sun dried and burnt, and after that the water is allowed to leach out through the collected burnt ash material, and then it results into the formation of this kola khar, which has got a lot of antiseptic qualities or medicinal values. Secondly, it is very, very basic in nature, that is its pH is around 13. So that is why this kola khar is also used to neutralize soil acidity. Apart from that, this kola khar is also used as shampoo and also as an additive in the food. So from this thing also you can see that whatever is coming out of the banana plant, that particular community has developed such kind of its implementation or the application of that banana plant or the residues of the banana plant, it is getting utilized in various elements like being a shampoo or a food additive or becoming a acidity neutralizer for the soil. The third example that we need to understand is the lemongrass, which is very famous in Kerala, and UPSC has asked question on the lemongrass itself, that lemongrass provides a lot of medicinal benefits, a lot of antiseptic benefits, and it is used whenever the grass grows dry. So ultimately the dry portion of the grass is used to create mats, so that ultimately the community is able to utilize whatever resources the nature has bestowed on them so as to solve their local problems. And that is the utility and the beauty of traditional knowledge, that every community is trying to take the resources which has been provided by the nature and to utilize it in the best way possible so as to provide solution, thereby enhancing the sustainability. And that is why the significance of, say, traditional knowledge is very, very monumental. However, what we need to note over here is that despite of the various benefits which have been provided by the traditional knowledge, ultimately it is very less accepted in the society. And the reason for the less acceptance is the lack of trust. And why there is a lack of trust? Because there is a larger public perception in the society that traditional knowledge, it lingers in the gray area between science and belief. And since there is a large scale pervasive element of science in present day society, so any element will gain trust in the society only when it is scientifically validated. And that is where the initiative of Swastik comes in. That is, the Swastik initiative, which has been launched by the National Institute of Science, Communication and Policy Research, it tries to validate those traditional knowledge which are present with the human beings by scientifically validating him and then bringing in front of the society so as to build more and more trust with respect to the usage of that traditional knowledge. And this is the core context that why we had needed the Swastik initiative. Now let us try to come and discuss the initiative called Swastik. Now, as we already noted, the why behind the Swastik initiative, that is to build public trust for traditional knowledge. Now, the core objective of the Swastik initiative is twofold. Firstly, to document all the traditional knowledge which is available, because it might be a possibility that various communities are solving the problems which we at urban living people, we might find very less viable solutions to it. And there might be a possibility that various communities are trying to solve those problems in a very easy manner by the traditional knowledge that they have harnessed through centuries. And secondly, the objective of the Swastik initiative is to promote and disseminate the traditional knowledge after scientifically validating it, so as to mainstream it. That is the core objective of the Swastik initiative, which has been launched by National Institute of Science, Communication and Policy Research. Okay. Now, ultimately, if these are the objectives, then what are those features of the program which is trying to help achieve these two objectives? So, the first feature will be creating content, creating easy content which can be published over the social media platforms. And these contents, whether be it audio, podcast or video, they will be talking about the various benefits of different kind of traditional knowledge which is available with the communities of our country, so that more and more adoption of such traditional knowledge can be done through our society itself. Just like Pradhan Mantri Modi ji had showcased such pictures on his Twitter handle, it led to the bombardment of various kind of likings for the Punganur cow breed. So similarly, if we will use social media platforms effectively, then we can definitely mainstream various kind of traditional knowledge which are available, which provides very cheap and viable solutions to the persisting problems that we are facing. The second feature is crowdsourcing or doing literary surveys and involving and employing various kind of researchers to engage with the community, and scientifically validate the traditional knowledge. And thirdly, to enhance more and more public engagement, what the Swastik initiative does is that on a regular basis it conducts various kind of workshops, seminars in various schools and colleges and conferences, just like the Swastik initiative had conducted the conference of CDTK, the second international conference, that is the communication and dissemination of traditional knowledge, so as to promote the traditional knowledge among the society. These are the core features which ultimately is trying to help achieve the objectives. So whenever we are trying to learn any kind of governmental scheme, always try to understand that every scheme has an objective, and to fulfill those objectives there are certain features which is leading to the completion of these objectives. So these two objectives are very important, and these are the features through which the Swastik initiative is trying to fulfill those objectives. Now let us try to learn about the institution which is trying to implement and administer this particular scheme. So briefly, as we already noted, that this scheme is an initiative of National Institute of Science Research and Policy Communication. Now similarly, let us try to learn about it. It was established in year of 2021 with headquarters in New Delhi, and it was created by the merger of two very important organizations of CSIR itself. First was NISCARE, that is a short form for National Institute of Science Communication and Information Resources, and secondly another institute of CSIR, which is the National Institute of Science, Technology and Development Studies. So when these two merged, ultimately it led to the formation of NISCPR. And what does it do? Ultimately it acts as a think tank for the science, technology and innovation ecosystem. And ultimately, as from the name itself, it is quite evident that development of science is one thing. However, we need, as a society, the government needs to take that science or its application of science to the society, so that the overall level of scientific temper can be enhanced in our society. And how it can be done? It can be done only through a dedicated organization whose work is to communicate the various kind of scientific values and their application in the society. And for the case of India, NISCPR is that particular organization which is trying to take science closer to the society. So this was all about this particular topic. Now let's come to the next topic, which is the Bibek Debroy Committee report. So why we are trying to learn this thing? So ultimately, in a very unfortunate event, Bibek Debroy, he recently passed away, and he was one of the most India's prominent public intellectual. And what had happened is that there is an important body by the name of Prime Minister Economic Advisory Council, and Bibek Debroy was the chairman of that particular important body called PMEAC. So ultimately, Bibek Debroy was a very important public intellectual who has taught in various important public institution or academic institutions of our country, and has provided a lot of journals and research papers in the field of economics and public policy. And one of the most important contribution which was made by Bibek Debroy was the Bibek Debroy Committee, which was there to recommend suggestions for the restructuring and rejuvenation or reformation of the Indian Railways. So in 2014, the Railway Board constituted a committee with Bibek Debroy as chairman. And it was provided the responsibility to look into the reformation and restructuring of railways. And in this pursuit, in June of 2015, Bibek Debroy Committee had submitted its report, and the report had provided certain observations and recommendations, which we will try to learn now. So what are the key findings and recommendations which has been provided by the Bibek Debroy Committee? So the first important finding or observation of the committee was the failure of private participation within the functioning of the railways. So the committee found out that the private participation is very less in the railways. Why? Because there were two reasons to it. Firstly, there are three roles which are performed by the Ministry of Railways. Firstly, of policy designing. secondly of regulation, and thirdly of operations. And the committee opined that the Ministry of Railways is doing all the three important jobs, and that is why it is hindering the private participation, because ultimately Ministry of Railways is at a very dominant and is sitting at a very monopolistic situation, which is creating such an environment which is like degrading the possibilities of private sector investment in the railways. The second important aspect which was noted or like observed by the committee was that even if there were schemes for private sector participation, it was designed in such a manner that all the risk to the investment were lying with the private sector itself, and that is why it created a disinvestment for the private sector so that they should not invest money in it. Now, the second important observation of the committee was the need for an independent regulator. Now, it is the second recommendation of the committee is drawing from the first part itself. In the first part itself, we discussed that the Ministry of Railways is at a very dominant position or at a very monopolistic position, and it is hindering the participation of private sector. So, therefore, to promote fair playing ground for all the stakeholders, whether be it government by the name of Ministry of Railways, or any kind of private parties, or any kind of NGOs who is trying to participate in delivering services to the railways. To promote fair playing ground, there has to be an independent regulatory body by the name of Railway Regulatory Authority, and this Railway Regulatory Authority will be an independent body with its own budget, and the core job of this Railway Regulatory Authority should be to scrutinize the tariff. Now, the committee was very clear on this particular point that this independent body will not set the tariff. However, whatever the tariff is being set by the government, the Railway Regulatory Authority will try to scrutinize and examine the tariff, and they will try to see whether this tariff is competitive or not. And that is why this particular suggestion, that is the second suggestion, is very important. The third important recommendation was of addressing the financing issues. The committee observed that ultimately there were a lot of financing issues in the railways because of following factors. Why? Because there were investment was required where there is no traffic of railways. Since there will be no traffic in certain areas, it will not lead to revenue generation. So if there is no revenue generation, why would any private party would want to invest in that particular project? And it is very easy to understand this particular point is that there are certain areas in our country where there will be less traffic. For example, if you want to generate railway infrastructure in the northeastern part of our country, or any hilly areas, or any hinterland of our country, definitely population density is less over there. So more like the traffic will be less, and it will lead to lesser of revenue. So ultimately nobody wants to invest in such projects where there is lesser of a traffic. Second kind of projects are there is imbalance between freight, that is the goods, and passenger traffic. Such kind of situation also results in lack of revenue discovery for the private investors. And thirdly, that there are project delays, and because of the delays there is cost escalation. And ultimately these are the important elements that the committee recommended that the railway should focus on so as to garner more and more private investment. The fourth point which railway had suggested is that the railway is distributed in 17 zones, and these zones were designed keeping in mind only the administrative aspect, and it is very colonial in origin. That since there are 17 zones in our country, and the committee had recommended that there is a need to restructure the zones into lesser number of zones so that it will cater to the need of lean railways, lean and efficient railways. After that, committee had recommended that the railway should focus on the core activities. What do we mean by core activities? So railway, apart from like guiding the policies and regulating and also doing the operations, it also does certain non-core activities. And what are these non-core activities? So non-core activities are administration of their own townships, providing medical facilities or running hospitals, running schools, etc. So the committee was of the opinion that railway should try to do away with such non-core activities, and these non-core activities can be outsourced to the private sector players so that railway can focus more on core activities, which is nothing but management of the traffic, infra development, and improving efficiency. These are the core activities. And lastly, the committee has suggested that the railway board chairman should be redesignated as the chief executive officer of the railways, and this particular initiative had been accepted by the government, and the railway board chairman had been redesignated as a chief executive officer of the railway, so that ultimately the CEO will be having more autonomy to take swift decisions in favor of railways. So these are the core of the observations and recommendations which were provided by the Bibek Debroy committee. As railway is the largest logistic player in our country, and it has got not only the economic but also socio-cultural significances, the proper implementation in spirit of the Bibek Debroy committee is very important to reform and restructure railways. Let's try to come to the next topic now, which is interstate council. Now, what is the context again? So recently the government of India had constituted the interstate council with PM as the chairman plus 6 union cabinet members and 13 union council of ministers as permanent invitees. Now, what is this interstate council? What are its functions and why we are trying to learn this thing? Now, let us try to understand it. So, there is a very important constitutional provision called Article 263. So, what does it mean? That Article 263 provides for the constitution of interstate council. Now, to define interstate council, it is a very simple thing, that interstate council is nothing but a constitutional body which was created in the year of 1990 based on the recommendations of Sarkariya Commission, with what objective? To provide for a institutional framework. Institutional framework to do what? To settle conflicts and to enhance more policy coordination between which elements? Between union and states and between different states as well, so that ultimately it will lead to strengthening of our federalism, and if the federalism is healthy and strengthened, ultimately our democracy will be strengthened. So that was the core philosophy behind creation of the interstate council. However, to understand it in its quite depth, we need to understand the Article 263 of the Constitution as well. So what does the Article 263 says? Article 263, it says that, it reads as, President at any time, if it sees that public interest will be best served by the constitution of an interstate council, with following three functions. Firstly, to inquire and advise into any disputes which might happen either between among the states or between the states and the center. Secondly, to discuss and deliberate on various issues for which both the union and the states are common party, or both union and states are showing interest. And thirdly, to provide recommendations on certain matters of policy coordination. So constitution is very explicit with respect to the the functions which has to be provided by the interstate council. So these are the three functions which have been provided by Article 263, and the president at any day they can actually constitute it by issuing a notification for the constitution of interstate council. Now what is the composition? Let's try to come to the composition part of it. What is the composition of interstate council? So ultimately the chairman is Prime Minister. Apart from it, it comprises of chief ministers of all the states and those UTs which have legislative assembly. For those UTs which do not have legislative assemblies, there has to be administrators of those UTs. Apart from it, the interstate council will comprise of 6 cabinet union ministers, and the chairman can provide for permanent invitees. And as we have noted in the context itself earlier, that while it was constituted now, this interstate council was constituted, the chairman had provided for 13 council of ministers as the permanent invitees for the this recently constituted interstate council. Now let us try to understand the functions and what are the limitations in the functioning of this interstate council. Now the function is very, very simple. Let's try to understand it in a diagrammatic fashion. Firstly, it provides for institutional framework. What do we mean by that? That ultimately it is providing an institution, mechanisms and processes where both center and the states, and center and state on one hand and certain states on another hand, they can discuss and resolve the various kind of disputes or issues that they are facing without creating a need to go to the or approach the courts of our country, because ultimately it leads to loss of money to the exchequer itself. The third is conflict resolution. What do we mean by conflict resolution? That whenever there is any impertinent issue which is being faced either between the states or between state and union, what this particular interstate council can provide is that they can provide with conflict resolution, and ultimately this might lead to creation of harmony within the actual functioning of the federalism of our country. And the third is of policy coordination. Now the government of India, both at the union and the state levels, they face myriad kind of problems which cannot be dealt at either level of the government. For example, climate change, poverty, unemployment, floods. So such kind of situations, it requires better policy coordination and collaboration between both the center and the state governments. And this interstate council will provide a very good institutional framework so as to provide for a more harmonized policy calibration, so that both union and state governments can come at a common platform and tackle the issues which are facing them and provide the society with a very viable solution. So this is the core functions which are being performed by the interstate council. However, what are the limitations? So the first is the infrequent meetings. Now, since as from the constitution itself, we can see that Article 263 provides for the formation of interstate council. However, you will be surprised to know that this interstate council have been sitting in a very infrequent manner. The last time it was constituted, it was in the year of 2016. So the last meeting was held in 2016. This shows the focus or the emphasis the government is trying to give to the interstate council. Secondly, advisory nature of the recommendations. Now, as we know that whatever the recommendations or the advices the interstate council will give to either the state governments or the central government, they are mere advisory in nature and are not binding onto the either levels of the government. So ultimately, whatever good work they are doing, that is not getting implemented on the ground. The third is political calculus. That is, sometimes the union government is run by different parties and the state governments are run by different parties, and since there is a ideological rift between the two ruling parties at the state and the central, it results into creation of ruckus in the functioning of the interstate council itself. And because there is an ideological rift and animosity, a feeling of animosity between the two different ruling parties, it leads to the diminishing of authority of the interstate council as well. And for a federal country like India, which is humongous in size and it is facing a lot of challenges like climate change, poverty, unemployment, various kind of biodiversity losses or forest management, or whether it be the security issues of Naxalism, it requires more proactive and collaborated approach, not only among the states but also between union on one hand and the states on another hand. And interstate council can be a very important institutional tool at the hand of the governments, whether it be the union or the state, to utilize it in the best way possible and to provide very viable solutions for the complex challenges that our country is facing. So this was it for this topic. Now let's come to the next topic. Now this topic is inauguration of India's first Constitution Museum. So recently, India's first Constitution Museum was inaugurated at the O.P. Jindal Global University, which is located at Sonipat, Haryana. And the reason behind institution of such museum was that this November 2024, we completed 75 years of the adoption of our constitution. And to commemorate it, the O.P. Jindal Global University, they actually instituted the India's first Constitution Museum. Before we go on and discuss the various features which are present there in that particular museum, we should first try to understand why do we need museums. As we know that museums are nothing but institutions which contains various articles, artifacts, whether be it literature, painting, which reflects the glorious history of our country. Now, when we are talking about Constitution, Museum of Constitution, so ultimately that museum is containing artifacts, artworks which is related to the formation or the formulation of our constitution. So what is the need of such museums, or what are the significance of museums? Firstly, it is the repository. It is the repository of our cultural history. That it provides for the opportunity that whatever artifacts, artworks, documents which are presently available, they should be preserved and documented within the premises of that museum, so that ultimately it might not get lost. The second important function or the significance of a museum is that it provides for the avenues of learning. Museums are one of the biggest temples of learning, because since it is containing a lot of artifacts, arts, documents and various historical issues with respect to the constitution of our country, it will provide a very structured tool for any particular individual who wants to learn about the constitution. The third is that ultimately it is trying to bring in the communities together. That whenever there will be a museum, not only for constitution but also for other elements as well, that whenever people from different communities will visit that museum, they will try to identify that every community are sharing the common thread of the cultural legacy, and it will foster social cohesion in our country. And lastly, it will act as a tool for inspiration for the coming generations as well, because whenever a people will visit such museums, they will be in awe with respect to what kind of principles, zeal and zest the various constitutional makers were trying to show while formulating the constitution, and that is why it is going to inspire the coming generations of our society as well. So these are the core significance or reasons that why our societies need museums. Now let us try to see the key highlights about that Constitution Museum. So firstly, it provides for an interactive experience, that is there are 3D models and augmented reality versions of Dr. B.R. Ambedkar, which actually goes with Ask Me Anything format. So there is a hologram or 3D hologram of B.R. Ambedkar and you can ask them any kind of questions. And there is a time travel radio which narrates various kind of events which was going on in the 1940s and while the constitution was being formulated. Apart from it, it provides for a robotic tour guide also, that whenever like any visitor is trying to navigate the space within the museum, they should be done in a very guided manner, so that whatever knowledge can be disseminated through that guided tour, it should be done. Apart from it, it displays constitutional heritage through 1,000 photolithographic reproductions of constitutions and mini busts of 300 constituent assembly members. It also provides for interactive activities like digital quizzes and flip and learn exercises like using flashcards to actually teach the students or visitors about nuances of the formulation of the constitution. It comprises of audio-visual features like Samvidhan Theatre and armored cabled headphones which play speeches from the Constituent Assembly and explanations of constitutional philosophy. And lastly, it also displays the various arts and history through the paintings of judges and jurists on black and yellow background. So these are the things which are very important, and it's a very significant milestone for our country that such museums have been opening, and it is the need of the time that to cherish and to nourish the democratic culture in our country, more such museums has to be opened in various universities of our country. So this was it about this topic. Now let's come to the next topic.